Sovereign Series, Part 3, Section A, Understanding the Federal Constitution as Law. Up to this point, we've been talking about language, how words shape power, how meaning drifts over time, and how authority often hides inside phrases that sound familiar. Part 3 is where we slow that conversation down and return to the document those words come from, the United States Constitution, and begin approaching it as law, not as a symbol, not as a political prop, and not as the simplified version most of us were given in school. This part is broken into shorter sections on purpose, not because the Constitution is complicated, but because it's precise. So before we talk about branches, powers, or conflicts, we need to start with something more basic. What kind of document the Constitution actually is? The Constitution is not a list of permissions granted to the people. It doesn't create rights, and it doesn't exist to tell citizens what they're allowed to do. Instead, it does something far more specific. It creates a federal government, and then immediately limits it. The Constitution is a delegation document. That means it assumes authority already exists elsewhere, and then carefully assigns certain powers to a new governing body, while leaving everything else untouched. This is where familiar phrases can start doing more work than the document itself. When the Constitution is referred to as the highest law of the land, that authority does not belong to the federal government. It belongs to we the people. The Constitution holds that position because it was ordained and established by the people themselves. The federal government does not stand above we the people. It exists because of us, and it is bound by our terms. When that distinction is lost, authority shifts upward, and over time we forget where it actually resides. The Constitution's authority comes from we the people, and its purpose is government restraint, not unlimited power. Another way to understand that restraint is to recognize what the Constitution actually is. It is a contract. Specifically, it's a contract between we the people and the federal government, one that creates the government, defines its duties, and limits its authority at the same time. In contract law, authority comes from agreement, from the terms and conditions that are spelled out within it. That matters, because contracts don't grant unlimited permission, they define and bind the parties entering the agreement. And like any contract, its legitimacy depends on staying within the framework it was authorized to operate in. Having said that, let me be clear. The federal government exists because of the Constitution, not the other way around. Every power the federal government holds had to be named, specifically enumerated, and the act of naming those powers was meant to limit the federal government, not we the people. In other words, if a power isn't delegated, it isn't missing. It was intentionally withheld. This is why it's important to approach the Constitution from the perspective of contract law. The Constitution is not merely a historical document, nor is it subject to unauthorized and unlimited amendment by the very party it was meant to restrain. You're not looking for inspiration. You're not looking for permission. You're looking for contractual structure. What was created? What is it allowed to do? And just as importantly, where do its powers end? Those questions are answered by the document itself. So as we move through Part 3, the goal isn't to memorize clauses or argue interpretations. The goal is to relearn how to approach the document, slowly, deliberately, and on its own terms. With that foundation in place, we can begin to understand why the federal government was designed the way it was, and why that design still matters. And remember, we don't fix it by burning it down. We fix it by understanding what was built, how it was meant to function, and where its limits actually land.